Hello, everybody. Good morning. Welcome back to another live. We just did one yesterday. If you missed it, it is up. I had to clip a little part out of it. If you missed it, you probably won't even miss it, but it's back up. I am here. We have another new filing. So I hate these fake eyelashes. Anyway, I had them done for my engagement. It's not something I do all the time. Okay. So if you were here yesterday, we read the document from Britney's lawyer that basically is asking Jamie, or asking the court rather, to force Jamie Spears to sit for a deposition. A deposition is basically where you sit someone down in a lawsuit type of situation and you ask them questions. Usually they are several hours long, and sometimes they're even like days long. So Mathew Rosengart, in the filing from yesterday that we read together, basically is telling the court, look, Your Honor, we have asked Jamie to appear for a deposition no fewer than 3 times. We have offered him countless dates. We've offered him like 8 different options to show up and do this deposition. We've even offered to fly out to Louisiana and do his stupid deposition there. Your Honor, please make Jamie sit for a deposition. So that's basically what yesterday's filing was about. So while we were reading that filing, we saw some other hints that there might be another filing coming soon. And I did mention that in the live yesterday. So he said yesterday, Mathew Rosengart said yesterday in his filing that he would reserve his right, like Britney was reserving her right to still request and demand other things. If you're looking at my hands, they're not dirty. It's this Mendy is wearing off. So it's not dirt. It's just stained. So in the filing yesterday, Jamie Rosengart actually said, we reserve the right to request and demand more things other than just this deposition, because he's also stalling on other things as well. So sure enough, as we predicted yesterday, this document now has dropped. So what we're going to be looking at today is something in my eye, sorry, is one of actually 3 documents. Let me get to the first page here. So I will show y'all the website. So this is the court document. This is the court website, right? lacourt.org. It's publicly available. So as you can see, this is the most recent documents. These are the most recent documents that have been filed. You have May 25th was a declaration of Mathew Rosengart in support of Britney, which we did not read, but it is in my Google Drive if you would like to read it. A couple people yesterday asked me to skim through it, which I actually may do today. So let me make a note to myself. I will skim through that for y'all. And if there's anything really important, we'll just do another live. Because I really like to be up to date on everything going on in the case. Okay. But it is, as you can see, 199 pages long. Then we had yesterday, this is what we read. Hold on. Yes. Yesterday, this is what we read. It was 21 pages long. Motion to compel Britney's notice of motion and motion to compel the deposition. Remember the deposition. Okay. So since we did that live, these 3.4 documents have come on. 3 are of import. This is the one we'll be reading today. It is Britney herself, motion to compel the production of documents. Now, I do want to let y'all know, just this morning, I spent, I don't know, like maybe $25. Yesterday, I spent $50 of my own money. A few of y'all did send me donations, super chats, etc., to help me reimburse that cost. Thank you very much for those who did that. But unfortunately, I just was not currently able to get these other 2 documents. As y'all can see, excuse me. As y'all can see, this one's 375 pages. This one's 230 pages. Right now, as we sit here today, y'all know I'm not working. I don't have any income. So I did get this one, the 43-page one. And if y'all really, really want me to read these other 2, I will get them. But I need to get like a lot of comments that y'all really want to see this. Because what it is, and I haven't seen it. I haven't bought it. It's a 375-page document. I assume most of these pages are exhibits. That's why I didn't buy them. but it says Britney Jean Spears' separate statement in support of motion to compel production of documents. And then there's another statement by someone named Lisa McCurdy. Now, who is Lisa McCurdy? That name sounds very familiar. Oh, Lisa McCurdy is the second lawyer, I think. Let me see. Is the Greenberg Traurig lawyer. Yes, yes. Okay, this is who she is. I think might have seen her in court before. So this is her. We so far I think we like her. She is representing Britney. She's like a litigator. Okay. So this is the court website. She has filed a 230-page declaration in support of Britney's motion to compel, and that is probably, if I got all those documents, it would be close to $100. But if y'all really, really want to see those documents read, I'm not gonna read the whole thing on live. That would be Christina. Okay, well, Christina has spoken. Thank you very much. I will get the documents. Thank you very much, Christina. That makes it a lot easier for me to read them. Okay, all right. Okay, I'll do them. I'm gonna do them. I'm gonna order them after this live. Thank y'all. Y'all really want to see them. Okay. All right. So today, for this live right now, let's just get into the 40-page one. So what we're going to be reading is this one right here. Britney Jean Spears' notice of motion and motion to compel, not a deposition, but production of documents. Okay, so let's get into it after no more further ado. As you can see at the top, it was filed on May 31st. Let me get my comments up because I don't know if Monica's here. And sometimes y'all get a little out of hand. Not y'all. Okay. Oh, M3 was about to buy them. Oh, and also I always make these documents available in my Google Drive. So the one we're reading today is available for free. Y'all do not have to pay for it. It is free. It is in my Google Drive. Okay. So here we go. So yesterday, like I said, we read a very similar document, and I have a feeling we might get a little bit of deja vu here today, but that's okay because we need to know what's going on here. Okay, so last time we're reading the title, Britney Jean Spears' notice of motion and motion to compel production of documents requested in notice of deposition. Okay, so I don't know what this means, requested in notice of deposition. Maybe it's like, okay, yeah, we already told you what we were going to ask for in the deposition. And then, of course, they enter the memo of points and authorities. And then they tell you, right, filed at the same time. That's what concurrently means, at the same time, with declaration of Lisa McCurdy, a separate statement from Britney, and then a proposed order. Okay. And this also, they're wanting it to be heard on July 13th. So I was speaking with Free Britney RVA yesterday, Justice for Britney RVA, Jennifer, and she told me there was like 3 different court dates coming up in this case. Let's just look at that, actually. Sorry, I know y'all are here for the document, but I'll put a timestamp below as to what's going on because I want to see what's going on in this case, on which dates things are going on. Case calendar is what I should have gone to. This is just lacourt.org. You don't have to be a lawyer to do this. You can look this up yourself. I guess I'll agree with this. Okay, search by case number. Britney's case number is B as in boy, P as in Peter, 108870. And then let's see if we can get case calendar on here. Sometimes I like to show y'all how let's see. Sometimes I like to show y'all how I find this stuff. Okay, here we go. Case calendar. So on the 13th is a hearing on this item that we're talking about today, like forcing Jamie to go in for a deposition, etc. And then you have on a week later on the 20th. Now, I have a feeling some of this stuff could get consolidated. We still do have 2 months before the court date. So, or a month, a little close to 2 months, a little less than 2 months. So I think some of this may get consolidated, but we may have 3 separate court dates in July. Okay. So on the 13th is the motion to making Jamie do stuff, right? Making Jamie do his deposition, making Jamie do his documents. On the 20th, there is a petition hearing, and I don't know what that's on. And this is the one I'm going to be at for sure. the 27th. So they have a case each. I guess this is probably Wednesdays. 7th or so July 13th. And then a week later on July 20th, there's a petition. Then a week later after that on July 27th, there is the TriStar accounting hearing. Now, this has been put off for years. This is the accounting from 2019 or 2020. I believe it's 2019. It's never been approved. I believe it might be 2020. Then there's some other motions, order to show cause. So it looks like the big court date is going to be on the 27th, and that's the one I'm going to be at for sure. I might be at the other ones. I don't know, y'all. I mean, honestly, it's just what I have time and money for. If I had unlimited money, I would be at all of them, but you know how it is. Okay. And plus I have other stuff to do. My sister is going to have a baby soon. We're going on a vacation soon. Okay, so that's what's going on. If y'all were wondering what's going on in Britney's court case, get out your pens, get out your pencils. On the 13th, there's a hearing for Jamie Spears' deposition and Jamie Spears showing up for it to be deposed and him giving these documents over, which is the document we're about to read right now. So that's on the 13th. Then on the 20th, a week later, there's like a little petition. I don't know what it is. I'll have to do a little more research for y'all. I can update you on the next live if y'all remind me. And then on the 27th of July is like the huge big hearing. They're going to have 1, 2, 3, 4 items on the docket, including, I think, Jamie's fees and Lou Taylor TriStar accounting. Thank you so much, Anita. Okay. So now, actually, without further ado, let's actually read this document. Again, I think it may be a little bit deja vu for us from yesterday, but let's see what Matt Rosengart has to say. It's about the same length as yesterday's. It's about 20 pages. Okay. To the court, all parties and their attorneys. So this is what's called a notice, right? See how they call it notice? Notice of motion, right? So this part we're about to read is the notice. The notice. Thank you so much, Jennifer. I believe you will also be there. Okay, Los Angeles. Okay. Please take notice to the court and all you lawyers and all you parties to the case. On July 13th, or as soon after, Britney moves pursuant to California Code of Civil Procedure 2025, blah, 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 for an order. So Britney makes a motion for an order from the court compelling Jamie to produce all documents requested in his second amended notice of deposition. Okay. Good cause exists. So just to give y'all a sense of exactly what, same judge, yes, Mona, same judge that will be hearing this, I believe. Did anyone see Britney's Hello Yellow post? Yes, I did see it and I am concerned. Okay. So just so y'all are aware what's going on here, we have 2 separate documents from Britney and Matt Rosengart, and these are going to be requesting the similar types of things. In a case such as this, you have what's called discovery, okay? Discovery is whenever each side of the case gets to request certain relevant information from the other side and from other people to make their case. So in a typical case, each side would have to turn over documents that were in their possession exclusively. In this case, Jamie Spears is very obviously, it's very well settled. He is required by law to turn over certain information to Britney and Matt Rosengart. One of the things that they're required to turn over by law, for example, are the text message communications between Jamie and his lawyers for the conservatorship. So he's got to turn over text messages, WhatsApp messages, email messages, all of that. Other stuff they got to turn over, right? Like they have to account for their administration of this conservatorship. They have to turn over certain financial data. They have to turn over books and records. They have to turn over all of the documents that they had in creating these new businesses in the conservatorship over the last 13 years. And so far in the case, according to Britney and Matt Rosengart, that has not happened. So this is what this filing is about. They're going to the court and they're asking the court, just like yesterday, we read the deposition request or, notice of motion to make them have to do it. This is the same thing, except here we're not asking Jamie to sit for a deposition. Here we're asking Jamie to turn over those documents that he is required by law to turn over, and he has not done so. Okay. I do have a PayPal and it is listed below. Okay. So we're on line 7 here. Good cause exists to grant this motion. Why? Because despite the 3 deposition notices, Jamie still has not appeared for his deposition. And wait, why are they talking about deposition? No, this is it. Okay. So he's still talking about the deposition. And the reason that he's talking about the deposition is because it's all part of the discovery process, right? Depositions and documents and interrogatories are all part of the discovery process. So they do necessarily have something to do with each other. Does that make sense? Okay. Mr. Spears, that's Jamie, still has not appeared for his deposition. And despite unlabeled, disjointed, and incomplete document dumps on third parties, Jamie has failed to produce any of the documents in direct response and pursuant to deposition notices, let alone has he labeled any of those documents or correlated them to specific requests. So, just so y'all know, in a court case, when you turn over these documents, and sorry, I know that some of y'all don't like when I stop and explain this stuff, but that is what I do on this channel. If you can read this by yourself, I'm sure you're smart enough to do so. Go click link below and do that if you don't want all my stops. Okay. It's free and I provided it for you for free. Okay. So in this situation, generally, like if sorry, I have something in my eye. I keep touching it. Both sides usually will just cooperate. I mean, there's always like sometimes, there's certain things that the side doesn't want to turn over. And sometimes those items will go into the dispute. But generally, there's like a lot of documents that each side is just like, whatever, I don't care if they have this here, right? But when you do that, you have kind of like a responsibility. Each side has a responsibility to kind of like do it in good faith. Like you're not supposed to just like dump a bunch of documents on someone and say like, oh, the answer's in there somewhere, right? They are supposed to, each side is supposed to operate in a good faith manner to label and organize the things that they turn over to the other side in these document requests and in these discovery requests. What we're about to read from Matt Rosengart, I'm assuming, is that Jamie has not done that. Yeah, he turned over some stuff to us, but it was like all unorganized. It was disjointed. I didn't know what anything was from, right? So that's basically what seems to be the case that's going on here, which doesn't come as a surprise to me at all. And I'm sure it does not come as a surprise to y'all either. He has also failed to produce any and all documents, including communications between himself, TriStar Sports and Entertainment, Black Box Security, and his current or former lawyers, as is required by law. Concerning specifically the illicit surveillance operation at issue, which was exposed by the New York Times on September 24th, 2021. Rosengart goes on to say, instead, in response to the deposition notices, he has only asserted voluminous and improper blanket objections without any documents. As we have stated before, Mr. Spears can run, but he cannot hide forever from his legal and fiduciary obligations. His stonewalling and obfuscation must not stop the full truths from coming to light. For present purposes, it is only required that the parties spend unnecessary resources in a protracted battle to obtain his compliance. Okay, so we actually read this exact paragraph yesterday, and Matt Rosengart is saying, look, listen, the only thing that Jamie stalling is doing is making us all have to waste money and time. So it needs to stop. After using his daughter's money for more than 13 years to fund his legal fees and expenses, for the first time, Jamie will now have to pay his own legal costs and fees. Britney's lawyers engaged in extensive meet and confer discussions with Jamie's lawyers regarding his deposition, and we also attempted to meet and, have a conversation with them regarding his objections to the document requests accompanying the notices of deposition that were served upon him. Jamie's lawyers declined to reciprocate the offers, which forced Matt to have to file this motion in addition to the earlier motion, which we just read yesterday, which compels his deposition. Based on the recalcitrance and silence of Jamie and his lawyers, it is evident that he will not properly produce the documents at issue unless the court intervenes. This motion is based upon the notice of motion accompanying this document, the memorandum of points and authorities, the declaration of Lisa, exhibits, pleadings, papers, and other documents on file in the matter. All matters upon which judicial notice may be taken, and the argument of counsel at the time of oral argument on the hearing. So that's going to end up being on July 13th. So here's our table of contents. We're going to go through the procedural history again. Oh, wow, that's amazing. When I clicked on the procedural history in the table of contents, it brought me to the section in the document. That's cool. Awesome. Okay, cool. I knew that existed, but like I didn't know that this particular document downloaded from the court would have still kept that feature in. That's pretty cool. Okay. Then we're going to go to the legal discussion about Jamie waiving objections, about Jamie needing to be compelled, the requested documents at the heart of discovery. Mr. Spears' boilerplate objections cannot block access to the critical documents. And then he's going to support those points. And then it'll go to the conclusion. So let me just settle in because I have a feeling this is going to take a while. So make sure you'll have your snack, your water, your whatever you're doing. I actually like almost completely lost my voice last week, just like doing all that planning. So I'm a little weak in the voice box. Okay. And then they're going to tell us the cases, lots of cases, statutes. This is where, if you're writing a legal brief, this is where you would put the precedent cases that you're relying on. You would, oh my gosh, there's a Kanye West case going to be cited in here. Cool. Okay. And then after that, you would put the statutes, and then you would put the court rules and other authorities. And that's the order it goes in. Thank you so much, Jessica. Nope, no apologies. Thank you so much for the super sticker, Mona. Yeah, Crystal, I think this has something to do with it. Jamie is so terrified that the truth might come out if he hands over the documents and all the mighty people he's taken down with them. Yeah, I mean, listen, they're going to be in trouble when these documents finally get turned over, and it's inevitable. They have to. And by they, I just mean anyone who did anything wrong. If you didn't do anything wrong, you're not going to get in trouble, most likely. I mean, I don't think that's how it works. Okay. Yes, previously she associated yellow with help. That's why it is concerning. She's not afraid to say kiss my ass to anyone on her Instagram, but then it was deleted a few minutes later. Yeah, that's also going on at this time. Okay. So let's get into finally starting this document after all of the what do we have, 30 minutes of lead up, but I think it's important. We haven't really discussed where we are in the case in a while, and I really think I wanted to do that with y'all. All right. So now here we are, preliminary statement and summary of the argument. Despite running so again, this is written by Matt Rosengart on behalf of Britney. It's Britney's filing. Despite running a corrupted and conflicted conservatorship that stripped his own daughter of certain fundamental liberties, and this is huge, stripped his daughter of fundamental liberties is lawyer speak for unconstitutional. Stripping someone of their fundamental liberties in a way that is corrupted and conflicted is to imply that Britney's constitutional rights were violated because of Jamie's corruption. Now, individuals cannot violate your constitutional rights. It has to be the state or the government doing that. But the state and the government participated happily with this conservatorship. They put Britney into the 5150 hold. They escorted her. The police escorted her. There was helicopters and all of that. She got into the 5150 hold, and the courts put her into a conservatorship. So the courts did take away Britney's constitutional rights. And Mathew Rosengart is opening up this filing by saying he ran a corrupted, conflicted conservatorship that resulted in Britney's rights being taken away by the government. And then he was suspended as a conservator. Despite all of that, Jamie continues to act faithlessly, elevating his own interests above those of his daughter and her estate. He continues to harass and bully her by, among other things, stonewalling, obfuscating, and failing to cooperate with his discovery and fiduciary obligations. So he's not living up to his obligations. And more directly, by serving intrusive and abusive discovery on Britney, including seeking to take her deposition despite dodging his own deposition. Putting aside that this conduct is a violation of his legal and fiduciary obligations, Jamie's conduct toward his own daughter is indecent. He should cooperate rather than stonewall, and he should leave his daughter alone. This is the right thing to do as a matter of law and fundamental decency. Jamie recently forced a motion to compel. Jamie recently forced Matt Rosengart to motion to compel his deposition because he stonewalled and obstructed, including not showing up for his deposition since 2021, October. He now forces the present motion to compel now, right? So he recently forced us to make him, he recently put us in a position where we had to ask the court to make him do a deposition. And now we're back here again, Your Honor, a few days later, asking you to force him to do another thing, and that is to turn over documents. And Matt is saying, look, I am forced to do this. I am forced to do this motion because he will not cooperate. Instead of appearing at his deposition and producing the requested documents as is required by his fiduciary obligations, his legal obligations, and his repeated lies that his lies that he would unconditionally cooperate with complete transparency and no conditions, Jamie asserted a hodgepodge of boilerplate blanket objections, each of which is baseless. Mr. Spears, that's Jamie, Jamie's conduct and objections are particularly improper because he waived any right to even object when he didn't do it on time. Basically, he had a certain window of time to object. He didn't do it in that time, so he waived that right. Further, refuting his baseless objections, he himself directly and expressly placed his misconduct at issue when he did the following things. Number one, when he claimed he engaged in no wrongdoing, another lie. I'm going to call it lie, but I just want to be clear here. Matt Rosengart never says the word lie. He says demonstrably false statement, which in my opinion means lie. So I'm going to call it lie. But just to be clear, Matt Rosengart didn't say the word lie. I know some of y'all getting your feelings about that word, but that's what it is. A demonstrably false statement is a statement that is false and it is able to be demonstrated as false. So that's the same thing as a lie. I'm not going to sit here and confuse people about demonstrably false statement. It's a lie. Okay. So what Matt Rosengart is saying on this part of the argument is that Jamie himself put himself in a position to have his misconduct analyzed whenever he lied and said he engaged in no wrongdoing. He also put his misconduct at issue when he filed a petition in December 2021 to have Britney Spears pay for his newest lawyer's legal fees. That's big sloppy. On top of the fact that he already had paid himself $6.3 million from the estate at minimum that we even know about. Plus, but wait, there's more. He also paid many millions to his lawyers, all from the estate. For the reasons that I just said, and for more reasons that are available in the record, in addition to being ordered to appear and testify at his deposition, Jamie must be ordered by this court to produce the documents requested in the deposition notices that we served on him. In contrast to his disorganized, non-responsive, incomplete document dumps, it's kind of like when you just dump, whenever you have to pay a fine or a fee or whatever, and you want to be obtuse. So it's like, oh, it's $200. I'm going to pay it all in pennies and make you sit there and count it. Now, I'm not telling y'all to go do that. I'm asking you if you ever saw someone do that, right? Where it's like, you make it so impossible for someone even to sit there and do it that it's like, you shouldn't even have done that way. It's like proving a point. So basically that analogy of just I owe $100 speeding ticket. Here's some change sorted out. That's basically what Jamie is doing with this document dump, right? He's like, oh, okay, here's some documents. Figure out what all that means. Matt Rosengart is saying that doesn't follow his his legal obligations. His legal obligations require him to give it to us in some type of organized manner. It doesn't have to be like exactly organized how Matt Rosengart wants it, but it has to be discernible and readable. Y'all know what I mean? Yeah, good point, G. People want the change nowadays with the shortages. That's true. Okay. So he did document dumps, and these are disconnected from the specific, like discrete questions that we asked him. He must be compelled by this court to produce documents in an organized, professional manner, Bates labeled and correlated to the requests at issue. So a Bates label is just, y'all can imagine, right? Like in court cases, it starts to get a little confusing with all the numbers, like page 1243, like it's kind of hard to like keep everything organized. So if you have a Bates label or a Bates stamp, sometimes it's called, it's just like a specific number coding system that goes on the bottom or top of the page and lets you everybody in the case know, because it gets confusing. Think about it. Everyone turn to the November 15, 2021 email that Vivian sent to Geraldine. Like that would be very confusing. So we need Bates stamps or Bates labels, and it's just like a organization system. Okay, so now procedural history in the present motion. For purposes of this motion only, certain applicable facts are set forth below. A more complete set of facts is set forth in the record, including the declaration of that FBI agent, the former FBI agent from earlier this year, which provides a roadmap of Mr. Spears' misconduct. If y'all want to read that, I have a video on it and it's in the drive. The May 25th, 2022 motion to compel deposition of Jamie Spears, a copy of which is annexed as Exhibit A. So the document we read yesterday is attached to the document we're reading today as Exhibit A. Okay. So now we're going to go through the brief summary of Mr. Spears' misconduct. And this actually looks slightly different than yesterday. Maybe it's not. Maybe I'm imagining things. Okay. Oh, no, I'm not having a baby. Oh, Lord, no. I am not having a baby. I am not having a baby. That's my sister. Okay. It cannot be disputed, and even Mr. Spears does not dispute, that he, who reigned over the conservatorship for 13 years, has crucially relevant info concerning several pending matters. This info includes communications and documents concerning the following subjects, among others. So Mathew already told us, look, I'm not talking about everything here today. I'm only talking about some stuff. And, I'm just trying to give you a little bit of information. So whatever Matt chose to talk about in here, I think Matt probably thinks is very important. So let's see what he chose to talk about here. The information that he's looking for includes documents concerning the following subjects, among others that he doesn't mention. Okay. What's the number one bullet point? Why did Mr. Spears seek the wrong type of conservatorship? Meaning, why he sought a long-term probate conservatorship rather than a short-term LPS conservatorship, which requires a far higher burden for the petitioner and contains a statutory framework with stringent protections for the conservatee. Okay, so what's going on in this first bullet point is Matt is wanting to know, why did they say Britney had dementia, never show that she had dementia, and put her in a dementia conservatorship whenever California has LPS conservatorships, and that would have put a much higher burden on Jamie to prove, and it would have probably been easier for Britney to get out of because each year it has to be renewed. So Jamie needs to answer questions and needs to provide documents about why he chose the wrong type of conservatorship. Now, I just want to be very clear here. It is my strongly held personal and ethical belief Britney did not qualify for any conservatorship. It is my legal opinion Britney did not qualify for a conservatorship based on the evidence that was provided to a court. She did not qualify for an LPS conservatorship, and she did not qualify, in my opinion, for a probate conservatorship. It does not seem as though that is what Matt Rosengart is saying. So I want to be very clear that I do not agree with the fact that it was just simply the wrong type of conservatorship. Britney Spears should have never been put into a conservatorship, period, because she never legally qualified for any conservatorship, period. That's my opinion as a lawyer and as a disability rights activist, period. So I want to separate my opinion from what I'm reading here based on what, Matt Rosengart wrote. Okay. What else does Jamie need to answer some questions about and need to give us documents and communications about? So just so y'all know, let me just rewind real quick. Specifically, what Rosengart is asking for are communications about why they chose this conservatorship. So what Matt is looking for are the 2008 communications that say you should do a probate conservatorship, right? Whether it was in an email, whether it was in a text message, whether it was whatever. Jamie will probably say that those are not in existence because he talked on the phone about it, which I actually would believe. Criminals very often, and I'm not saying anyone is a criminal because no one's been convicted yet, but it wouldn't surprise me to find out that they committed crimes. And if that's the case, then why would they put it in writing? Sure, some people do, but it's not going to surprise me if there's not actually any information out there about, or actually any communication out there in writing about choosing this type of conservatorship or the other. But that is what Matt Rosengart is looking for. He wants communications and documents concerning what made Jamie choose a probate conservatorship. Okay. What else does he want? Communication and documents concerning Jamie's conflicts of interest in violation of California rules of court, which were prevalent as early as 2008. So he wants info, communication, and documents concerning Jamie's conflicts of interest. What else? Jamie's pre-conservatorship loan from TriStar Sports and Entertainment. There is a footnote here where where Britney and Matt reference the New York Times article, which did uncover a loan between Jamie and TriStar. What else does he want information about? The grueling 97 show international tour and other work imposed on his daughter almost immediately after the conservatorship began. He wants info and communications about the efforts to control Britney by prescribing lithium, a powerful and controlling drug with severe side effects. Okay. So Matt is accusing Jamie in this filing of attempting to control or making efforts to control Britney by prescribing lithium. What else? The spying operation, documented and corroborated by the New York Times, and then further corroborated by that special agent from the FBI, including a placement of a listening device in Britney's bedroom. They want info about this is all about Jamie's misconduct, right? They want info about the interception, monitoring, and review of electronic communications, including privileged communications between Britney and her prior lawyer. They want info and documents about all the payments to TriStar Sports and Entertainment, Black Box Security, and other third parties from the estate of Britney. Whether and to what extent the existence or purposes of all such payments were concealed from the court. Ooh, okay. So look, this one is basically saying, I want good communications having to do with anything that y'all hid from the court on purpose, specifically any payments to Lou Taylor or TriStar or Black Box, and any payments that y'all made on bugging equipment, spying equipment, anything like that. Did y'all try to hide that from the court? Because I have questions. The total sums of money obtained from the estate and the use or diversion of estate resources to benefit Jamie or others. The unexplained use of Britney's money or resources, including connection with the following: the court-ordered domestic violence restraining order, and what the court previously identified as extraordinarily high expenses for the Louisiana residents, including payments to Jamie's son-in-law's company, Advanced Media Partners. So This bullet point seems to be implying, as far as how I'm reading it, that Jamie used Britney's money in that court-ordered domestic violence restraining order case where he allegedly physically assaulted and abused his own grandchild, Britney's child. So it seems to me that Matt Rosengart is implying here that the fees and costs associated with Jamie's representation of that in that case was billed to Britney's estate. And Rosengart is saying, wait, but I have some questions about that. Also, as we discussed yesterday, money from Britney's estate went to Jamie Lynn Spears, never took a dime from my sister's husband. So maybe Jamie Lynn didn't take the dime, but maybe it was her husband, Advanced Media Partners. Because here we have Matt Rosengart saying the court previously identified extraordinarily high expenses, and that included payment to the son-in-law company, Jamie Watson's company. 2 more bullet points here about his misconduct. We need all the corporate formation documents for all entities created during the conservatorship for the benefit or purported benefit of Britney Spears or her estate. So y'all remember all them companies that we found, like they had closed down some companies and then reopened some companies and Baby One More Mark and all this stuff. They want the formation documents. And what a formation document is, I was thinking about doing a video actually about this soon, just to explain to y'all what a formation document is and what goes into starting a company. A formation document are the documents required to start your business. And in each state, they vary slightly, but it's pretty much the same across the board. You need some type of organization certificate or certificate of incorporation that basically just says, what is your company? Basically, generally, what is it going to do? You need bylaws in the formation of an LLC, for example, where you say not who's going to be, but who there's going to be officers. This is how the company is going to run. This is how we're going to do it. If it's publicly traded, these are the shares, all of that stuff. So Matt is saying, look, we've gotten all that we can get from the public record, but what we really need now is the true formation documents that are not available to us in the public record, because not everything is available to the public record. And then the final thing that they want to see is TriStar's business management agreement with Britney Spears or with the estate. Okay. And they're acting like that wasn't in writing. If y'all remember, Andrew Wallet was involved at that time as co-conservator. And there was a lawyer who used to work at Andrew Wallet's office, Katarina Peralt, who came out and said, we had that agreement and we had electronically stored documents. And I think that we do have it. But to hear everybody else say it, they're saying that they didn't store things electronically at that time. Nobody has that original agreement. And so either they're hiding that original agreement, they lost that original agreement, or it never truly existed. I don't really know which of any of those could be true. It's like 33%. For me, I don't know. I'm not leaning one way or the other, but that agreement is nowhere to be found. And the reason that agreement is so important, just so y'all fully comprehend, is because it would have laid out how much percentage Lou Taylor was supposed to be getting for each of her things that she was doing, right? Like 5%, 10% of this, 2% of that, whatever, right? It would have laid out what Lou Taylor's job is as Britney's manager, and it would have laid out how much money she was supposed to get. So if we know that, and then we later are able to figure out how much money she actually got, we can compare whether she was overpaid, whether she overpaid herself, et cetera, et cetera. Okay. So we're done with his misconduct bullet points. So now he's going to go on and say, these issues are, of course, directly relevant to several pending issues, including Jamie's legally meritless and morally abominable petition to have his daughter pay for his lawyers and his legal fees, on top of the millions he previously paid, including the $500,000 that he tried to pay Vivian Lee Thorene's law firm for a media tour. Mr. Spears further placed these acts at issue during the January 19th, 2022 hearing. And I was in the courtroom for that. If y'all want a refresher, I have a video on that. When his counsel made a number his lawyer, Big Sloppy, made a number of representations concerning the New York Times September 2021 reporting. So I was in there, and I'm going to tell y'all what. Big Sloppy was pissed about the New York Times whistleblower coming out and saying Jamie had worked to spy on Britney, right? So Britney was spied on. It came out in the New York Times, and then sorry, I wanted it to be like that. It came out of the New York Times. And then after it came out of the New York Times, they had a court hearing, right? So it was September was the New York Times. Then January, we have Big Sloppy in the courtroom, literally hollering and screaming about how basically the New York Times was full of shit. I mean, he didn't say those words as explicitly, but that's what happened. In response to Mathew Rosengart's reference to the bugging and the spying allegations, Jamie's lawyer stated unequivocally and without reservation, and this is true, I was in the room, that it didn't happen, Your Honor. Quote, didn't happen, Your Honor. As the New York Times reported and corroborated with the ex-FBI special agent, and then, it was re-corroborated, the evidence overwhelmingly, unequivocally demonstrates the falsity of this representation. So he's calling it a false representation, but it is a lie. Okay. So here we have Matt Rosengart saying, Big Sloppy said it didn't happen, Your Honor. That's a lie. It did happen. Jamie must account for his actions, especially, but not solely, the representations I skipped a line. Especially, but not solely, because he himself expressly placed his misconduct directly at issue. He's the one who wants his lawyer fees paid. He's the one who had his lawyer lie in court and say he didn't spy on Britney. He's the one who didn't hand over all of the documents we need. He's the one that put himself into this situation. So he has to answer these questions pursuant to those representations and his December 2021 petition to have his daughter pay his legal fees. Furthermore, in submitting his periodic accountings to the court, and remember, Lou Taylor and TriStar Sports and Entertainment would have been who prepared those accountings. Just remember that this whole time. In submitting his periodic accountings prepared by TriStar to the court for review and approval, Jamie, at the very least, failed to disclose, and in fact, he apparently hid it, he concealed the full spying operation at issue and the extent to which estate payments were associated with it. So look, Your Honor, in addition to all that stuff, in addition to everything I just said, he basically hid this from the court, that he was spying on Britney, right? He hid it. At the very least, he failed to tell you about it. And so we're assuming he used Britney's money to pay for it. So the accountings are incomplete if you look at it that way. Does that make sense? Y'all understand what I'm saying? Under these circumstances, the recently decided Court of Appeal decision in Hudson versus Foster warrants a thorough review and likely the setting aside of prior accountings, whether or not they were previously approved. Now, this is important because even since Vivian Lee Thoreen was still on the scene, we had all of Jamie's lawyers coming out and basically saying, look, listen, the court has gone through and approved all of these accountings already. Sam Ingham never raised a question about it. Do y'all remember like us talking about this before? Like that is Jamie's lawyer's side, and that's Lou Taylor's lawyer's position. We submitted our shit to the court and the court didn't see anything wrong with it. The court approved it and banged the hammer down. So why are you trying to drudge up old crap? That's Jamie and Lou Taylor's position, or their lawyers' positions. But Mathew Rosengart is saying, hold on, that ain't going to work, kids. Because look at this new case that was just now decided that I found. Hudson versus Foster. In a situation where a conservator hid or covered up relevant information about how people spent money, it actually can open up all those accountings that the court approved because the court didn't do anything wrong. See, that's what Jamie's side is trying to do. They try to make it seem like Matt is insulting the court. And as y'all know, because these judges are so tyrannical and high on their own supply and never get in trouble for anything and have all this immunity, they don't know how to act. And so if they feel disrespected by one side or another, a lot of times a judge will absolutely decide against you and just make it seem like it was for some different reason. So in this case, Mathew Rosengart, I think, is feeling like he needs to be very careful so that the judge doesn't get pissed off at him. Now, again, this is where we diverge because I'm not acting any kind of special way for a judge. I'm going to go in there and do what I need to do and say what I need to say. And that's why I'm not a litigator. That's why I was never a litigator. I went into corporate law because I knew that I would get in there and that judge would be some stupid idiot and I would have to tell them something like that. And then I would lose my case for my client. So what Jamie's side has done is actually very smart and masterful because they have twisted Matt Rosengart's arm into saying, Your Honor, Matt Rosengart is calling you an idiot. He's saying that you fucked up on those accountings whenever you didn't find something wrong with it. Well, thankfully, Matt is even smarter because he's now gone out and found this precedential case law. In this case law, it says you can set aside prior accountings even if they were previously approved by the court. Okay, does that make sense? As Hudson instructs, a conservatee, that would be Britney, and her lawyer, Sam Ingham, has no duty to investigate the accuracy of Lou Taylor's accountings before being alerted to information that would cause a reasonably prudent person to expect wrongdoing. Now, I might make a whole entire video on this because y'all know from yesterday's video, I actually have a personal lawsuit going on. I'm not involved in it like as a party, but like it's going on in my family. And there's this whole reasonably prudent person situation. But for the purposes of this filing and reading this today, as Hudson instructs, a conservatee, that's Britney, she had no duty under the law to investigate Lou Taylor's accountings before she was alerted to information that would have caused her to suspect wrongdoing. Now, here's where we have to suspend reality for a second because as y'all may or may not know, I'm autistic. So stuff like I take stuff very literally. That stereotype about it is true for me. So for me, it's like we have to live in a make-believe land. We have to live in a pretend reality and pretend like it's reasonable that nobody suspected Lou Taylor of wrongdoing. Because in my opinion, in my autistic literal opinion, it should have been so obvious to any reasonable person that Jamie and Lou Taylor were at least sorry, let me not get sued for defamation. Rewind. In my opinion, it is any reasonably prudent person, right? That's the legal standard. Reasonably prudent person would have said, wait a second. Lou Taylor is the business manager. She's in charge of hiring security, the handlers. She's in charge of Britney's career. And she's in charge of paying herself money from the estate. She's in charge of Britney's investments, Britney's businesses, Britney's concerts, Britney's tours. And not only that, but she also was the person who owned the agency responsible for telling the court all of this information accurately with pretty much no oversight other than the court itself. So in my opinion, a reasonable person would have suspected wrongdoing in 2007 and whenever Lou Taylor was allegedly stalking Britney and sending her pink hats and all of that. So I like that Matt found this case, but it is completely unreasonable that no one suspected wrongdoing for 13 years. Right? I mean, do y'all see what I'm saying? Or is this just, am I too in the weeds on this? Okay. So now we have an excerpt from that precedential case that Matt Rosengart is going to cite from. Where a conservator, in this case that would be Jamie, has misrepresented a material fact in an account, even if it was approved by the probate court, a party bringing a later action, like a lawsuit on behalf of the conservatee, does not need to show that the misrepresentation could not have been discovered prior to entry of the order approving the account. Okay. So I guess in this Hudson case, probably what happened was somebody figured out that a conservator did something wrong and then went to sue about it. Then the conservator did what we've seen Jamie and his lawyers do in this case already. They said, whoa, hold on. The probate court approved that. So you're going to have to take it up with them. It's already been approved. Well, this Hudson case says, yeah, that's cute. But if the conservator lied about a material fact in the accounting and the probate court approved it, you don't later have to show that the misrepresentation could have been discovered, shoulda, woulda, could. It's like, no. If you misrepresented, then those accountings come back open. And I'm spending a very long time on this because I know that this is where this case is going to head. And this is what Lou and Jamie's lawyers are going to try to argue. Those accountings have been approved, so they're not up for debate. And Matt is saying, beep, beep, beep. No. There's a new case out. It's as of last year, and it is back up for debate. Okay. So now Matt's saying, like I just alluded to, when we apply Hudson to this case, there is specific and credible evidence that phones being utilized by Britney were being monitored in real time, including her communications with her lawyer, Sam Ingham, and that an illicit listening device, a secret illegal listening device, was placed in her bedroom, which captured her private, intimate moments and conversations. If Jamie or others concealed that from the court, that he was using Britney's money to pay Black Box Security, TriStar, or anyone else in connection with those gross invasions of privacy, which are against the law, those concealments would be material because they're illegal and immoral and horrible. And if they were illegal, I'm sorry. And if they are material, which let's go all the way if, because this is a long sentence of ifs, right? So we're creating a hypothetical world, right? If Jamie concealed from the court that he was using Britney's money to pay Black Box or TriStar or anyone else, so if he hid that from the court, which Matt Rosengart is saying happened, that would be illegal and it would be material. It would qualify as, remember up here, the standard was material. It would qualify under Hudson. So if Hudson does apply here, the conclusion of Matt's sentence here is those prior accountings must be set aside. Now, what does it mean to set them aside? It means to throw them in the trash and start over. That's what it means. So here is a quote. A party may obtain relief from judgment when the other party concealed facts in violation of a duty arising from a trust or confidential relationship. So they're just giving us the quote from that case. Another quote. When a judgment is obtained through a fiduciary's violation of the duty of disclosure to the moving party's reasonable reliance on the disclosure is considered satisfactory for not presenting. Hold on. Let me read this through and tell y'all what it means. When a judgment is obtained through a fiduciary's violation of the duty of disclosure to the moving party, the moving party's reasonable reliance on the disclosures, of the fiduciary is considered a satisfactory excuse for not presenting a defense in a prior proceeding. Okay. So what this sentence is saying is, it's just giving Britney a little more defense, right? Because they're going to say Britney never questioned it. Britney's lawyer never questioned it. So this is saying, okay, but if a judgment in this case, I'm assuming would be the judge approving the accountings. So when the judge approved an accounting, but that happened because Jamie Spears failed to tell everybody the full picture, then the fact that Britney didn't do anything or didn't discover it is fine. That doesn't matter. It's reasonable. It's fine. It's Jamie's fault here, is what this would say when we applied it to our case here. Oh, I love reading Lou Taylor's name in a filing. Oh, I love reading Lou M. Taylor's name in a filing. The same is true if Jamie used money from Britney's estate to pay for legal fees that should have been absorbed by Lou Taylor, TriStar, or others, and not Britney Spears, as set forth in the November 2020 objections. So these objections, there's like 4 or 5 objections from the 2019 accountings, and we still haven't approved the 2019 accountings. So all of the stuff at issue that's going to come up on the accounting hearing in July 2019, in July 2022, this coming months, is going to be from stuff from 2019. So it still hasn't been approved because everybody's been stalling and we've been freeing Britney and things have been going on and it's been getting pushed and pushed and pushed. But this is now 2 years ago. So in November 2022, almost, a year and a half ago, Sam Ingham objected to Lou Taylor paying for her lawyers out of Britney's money. The evidence shows that Jamie's conduct violated basic conservatorship law, fiduciary law, and Rule 7.1059 of the California Rules of Court governing conservators. As the declaration of former FBI Special Agent Shireen Abadi discusses, his behavior also implicates state and federal criminal law. These are all proper and fertile areas for discovery. And while Mr. Spears' discovery concerns are understandable, the basis for his concern, which now must include contradicting his own lawyer's representations to the court, do not excuse him from complying with his obligations. On the contrary, they compel him to be deposed and produce all documents responsive to the requests. So now we're on to the present dispute. Mr. Spears' refusal to appear for deposition and to produce documents in connection with his deposition. The facts detailing Mr. Spears' refusal to appear for his deposition are well documented in the motion to compel deposition, which is attached as Exhibit A, and that's the one that we read yesterday. If you want to read it, it's linked in the description box below. The first notice was served on October 1st, 2021, when Jamie's deposition was noticed for October 20th at Greenberg Traurig in Los Angeles. The deposition notice required that documents be produced at the deposition. Specifically, the document request called for the production of all documents and communications relating to the electronic surveillance of Britney Spears, including but not limited to all documents and communications relating to the recording or listening device in the home or bedroom of Britney Spears. Jamie never objected to the deposition notice or the accompanying document requests. Instead, in an email dated October 13th, so 2 weeks after we sent him an email, he finally sent an email back. His former counsel, that would have been probably Vivian, advised that Jamie is in the process of hiring new lawyers and that Vivian was not available to defend Mr. Spears on October 20th. Lawyers for Jamie granted the, Miss Spears. So Matt Rosengart, sorry. I need a water break. Matt Rosengart granted the courtesy of rescheduling the deposition at that time, but also made it clear that the notice of deposition remained in effect. So then after that, Jamie's new counsel, Big Sloppy, represented in various written communications and in his November 1st, 2021 court filing that Jamie would, quote, unconditionally cooperate with the undersigned counsel and would act with, quote, complete transparency in producing all documents to Britney's counsel. Thus, for the second time, Jamie was served with an amended, okay? So first they had a notice of deposition. Matt Rosengart was nice and gave them an extension to let Alex Big Sloppy get up to speed. So then he amended it. See, amended, it's the same document with an amendment. What's the amendment? Probably the date, right? So a second notice, an amended notice, it wasn't a second notice, an amended notice, but we can call it first, second, third. That's fine. But really just for purposes of understanding how the documents are titled, it would be called an amended notice of deposition. On November 3rd, 2021. So the first one they wanted him to come to was October 20th, right? Remember that? October 20th. They said, fine, we'll give you an extension. Vivian Letharine isn't available. Big Sloppy needs to get caught up. Fine, let's do it on November 3rd. That's not that much more time, but it's a couple weeks. Excuse me, November 10th. They sent him an email on November 3rd, giving him a week to show up, and the amended notice. So the amended notice was the second time they sent him a notice of deposition and said, look, listen, you need to show up on November 10th. So first it was October 20th, then November 10th. The amended notice again required that Jamie produce the above referenced crucially relevant documents. For the second time, Jamie inexcusably failed to appear or produce the documents. So he just didn't show up for his deposition. On March 2nd, a second amended notice of deposition was served, but technically that's like the third one they've served him, right? The first was just the original, right? Then the amended, and now we're on the second amended. So it's the third time they tried to get him to sit down for a deposition. Noticing Mr. Spears' deposition for the third time for April 6th. So they gave him a full month, right? They sent him a notice on March 2nd. They said, you need to be available on April 6th, next month. That notice again contained accompanying document requests requiring that documents be produced at Mr. Spears' deposition. Okay, so for the deposition, Matt Rosengart asked Jamie to produce certain documents so he could ask him questions about them. Jamie did not produce those documents and did not show up for the deposition. Instead of appearing at his deposition, and despite his repeated claims that he would, quote, unconditionally cooperate with, quote, complete transparency, Mr. Spears baldly objected. He objected to that second amended notice. So instead of just ignoring it, instead of asking for more time for the April 6th one, he just objected. He said, no, I object, not doing it. Asserting boilerplate blanket objections. Boilerplate is kind of like, it's where you use like a template and you don't actually apply like what you're talking about to the current case. You're just using some template you got from online or another case or something. On the heels of Matt Rosengart's rebuffed efforts to meet and confer with the lawyers by email dated May 26th. Oh, this is new. Britney's lawyers emailed Jamie's lawyers requesting again, just now, y'all, like last week, requesting again to meet and confer regarding the client's objections to the document requests. In light of the impending Memorial Day holiday, Britney's lawyer, that's Matt Rosengart, also requested whether the parties could agree to a brief extension of the motion to compel deadline. To date, Mr. Spears' counsel has declined to engage in such a meet and greet. Thank you so much, Maggie, for the super chat. Okay. What does this sentence say? In light of impending Memorial Day holiday, Matt Rosengart requested whether the parties could agree to an extension of the motion to compel deadline. Okay. So this is what happened. All right. So this is all new information from this filing. On the heels of the rebuff, okay. So there was an email May 26th. Today is June 2nd. So this was like a week ago. They met before the Memorial Day holiday, the lawyers, he sent an email, Matt Rosengart did. And the issue is Matt Rosengart needed to have a certain deadline to file this paper we're reading right now, right? Like if you're going to file a motion to basically compel means force, right? Like a motion to force someone to do something. Matt still had a deadline, a window to do it as well. So Matt is saying, okay, well, I sent them an email and said like, hey, could you just be nice and like grant me an extension? And if we both, the lawyers, agree to the extension, the court will let us do it. Well, Matt's saying I asked him because there's a holiday, if he could, if I could let my poor like associates off work who've been working around the clock to have a little bit of a holiday. But the other lawyers on the other side declined to engage in meet and confer efforts. And then I had to file this motion anyway. Okay. So what's the legal discussion? Jamie objected to the second amended notice by asserting countless random template boilerplate objections that are legally impermissible, they are misplaced, they are contradictory, and they have been waived. As an initial matter, Mr. Spears, that's Jamie, fails to justify any of his objections with any facts, and none of his boilerplate objections are proper. It is important to bear in mind also that Jamie has an obligation as a suspended conservator and a fiduciary to turn over all relevant and responsive documents without any condition, regardless of the method of discovery sought. And then they have a precedent case here that says, as a fiduciary, a conservator owes a duty of loyalty that requires that he act in the highest of good faith. This fact is buttressed by, I think that means supported, by his new lawyer, Big Sloppy's own repeated claims of cooperation. Further, demonstrating regrettable gamesmanship and completely contradicting himself, Jamie's lawyer claims that he, quote, instructed prior counsel to withhold nothing on the basis of privilege. Yet his response to every single request for production includes objections on the basis of privilege. And then they're telling us to read McCurdy's declaration, Exhibit G. Let me make sure I write that down because Christina has very graciously donated to the fund for those documents. So when I'm reading McCurdy, I want to make special mention of Exhibit G because it's mentioned here on page, where are we at? 13. Okay. On the motion to compel documents. Okay. Because as y'all know, that document's like 350 pages long. So I'm going to have to like really pick and choose what I read, but I will make it available to all of y'all. And what is the declaration? I'll probably do that in the next couple days. Okay. Okay. We got to love doing a thing live. Okay. So his response to every single request includes objections on the basis of privilege. This type of Alice in Wonderland dissembling is unacceptable. I don't get it. I don't get the Alice in Wonderland reference, but basically what he's saying is Big Sloppy like repeatedly claimed he was going to cooperate. But if you look at this other document we just filed, his response to every single request is a rejection, is saying he's not answering it because it's privileged. So we just, that can't work. Okay. Mr. Spears. So what are we looking at here? Are we in the legal discussion still? Yes. Okay. Jamie waived objections to the document requests in the initial deposition notice. His conduct also violates his fiduciary obligations and his express repeated promises and representations that he would unconditionally cooperate with complete transparency. As a matter of statutory law, so there's two main types of law here, y'all. There's case law and statutes. Okay. Statutes are the ones that have codes attached, like according to state California rule, blah, 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 do, or whatever, right? Like, well, actually a rule of criminal procedure is not a statute, but like according to penal code, blah, 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 that's a statute, right? That's a little bit stronger than case law, but you can use case law as like, it's where a judge has interpreted the law a certain way. And now that is a law as well. So now we're talking about statutes. Jamie waived any and all objections to the document requests in the deposition notice that was served on October 1st. He didn't object when we told him about the first one. So the fact that now he wants to object to stuff, that's just not going to work because he had a certain period of time to do that and he did not do that. By failing to object, he now has no choice but to produce all the documents and communications that are responsive to the following requests, in addition to others. So these two he put in here and he really, really wants the court to know about. I mean, they probably sent like over 100 questions and he's only requesting two that he's putting up here, number 1 and number 2. And he's saying he has requested all documents and communications relating to the electronic surveillance, monitoring, cloning, or recording of the activity of Britney Jean Spears' personal phone, including but not limited to the surveillance, monitoring, cloning, iCloud mirroring, or recording of calls, emails, text messages, internet browser use or history, and social media use, or direct messages on social media. So they haven't turned that over, but Matt really wants it. Then we have request for production number 2. All documents, communication relating to any recording or listening device in the home or bedroom of Britney Spears, including all documents and communications related to the decision to place any such recording or listening device in and the records of any such recordings. So Matt wants to see the communications that related to the decision to place those listening devices. So he wants the communications between Jamie, Black Box, Yemeni, whatever that guy's name is, Iman, whatever his name is. What's his name? Iman Yemeni? Is that his name? Robin Greenhill, Lou Taylor, all of them. If there's communications, Matt wants to see. Deponent must timely. So that was statute. So now we're going to see Code of Civil Procedure. Oh, it is a statute. Okay. And then also a case law. And it says deponent, that's Jamie, must timely serve written objections before the deposition. If the deponent waits until the deposition to raise the objection, it is waived. If Jamie waits until the deposition to raise his objection to it, then he has waived it. Okay. And that is according to a practice guide, civil procedure before trial, the Rudder Group, deponent must. Okay. So that's called a treatise. And the deponent cannot refuse to produce the documents at the deposition. Okay. Additionally, and as referenced above, Jamie's counsel, Jamie's Big Sloppy, repeatedly and profusely promised that Jamie would unconditionally cooperate, right? Jamie's unconditional, transparent cooperation in producing all documents to Britney's counsel. Although these representations have proven to be false, aka although we now know Big Sloppy lied and he's a liar, they were made in an effort to create a false narrative and record, which and what has become a big lie of Mr. Spears' defense. Oh, good. Congratulations. Let's all go like this video because it is the first time that Matt Rosengart actually calls him a liar in my memory. He did put it in quotes, but listen, I'm glad that you are finally calling these people what they are, Matt. Although Big Sloppy's lies have been proven false at this point because he said Jamie was going to cooperate and he hasn't, they were made in an effort to basically create a false narrative on the record for the judge to make it look like Jamie is being cooperative when he's really not. They are relevant. And this has become a big lie of Jamie's defense. They're still relevant. So in addition to the fact that he has waived his objections by statute, he's waived them. He said, sorry, let me rewind. In addition to the fact that Jamie has basically given up his right to object to this stuff by, that's what a waiver is. His objections should just also be denied as a matter of fairness and equity. And he should not be allowed to do it. So even if he didn't waive it, even if he didn't wait too long and all that, even if that's not the case, we have more reasons why he shouldn't be able to get out of this document request. And they're the following reasons. Here's some illustration only, by way of illustration only. In an email dated October 22nd, 2021, Jamie's lawyer professed the following. There's 4 things here. So in October, this is what Jamie's lawyer said. Jamie will unconditionally cooperate with a complete and total transfer of all files regarding the conservatorship. Big Sloppy said, or this might have actually been Vivian. Mr. Spears was that Britney is welcome to everything and complete transparency without conditions. That Jamie would do everything he could to help facilitate the direct transfer of all files from prior counsel. And again, complete transparency without conditions. That was October 22nd. So about a week or 2 later, November 1st, in his quote status report, Jamie's lawyer, Big Sloppy, represented the following 5 bullet points. Jamie has nothing to hide and will therefore hide nothing. Jamie affirms that he will unconditionally cooperate in transferring all emphasis in original. Okay, so he actually did put the emphasis on the word all. Jamie affirms he will unconditionally cooperate, transferring all files regarding the estate to Britney's counsel, to Britney's lawyer, without delay. Now, this is in November. What are we in now? June? This is 7 months later, 8 months later. Jamie recognizes his ongoing and transparent participation is paramount. Jamie will unconditionally cooperate with a complete and total transfer of all files. Jamie is committed to complete transparency without conditions. Then again, in a November 5th email, and that one again is in McCurdy Declaration Exhibit D. Then again, 4 days later, in a November 5th email, Jamie's lawyer repeated the mantra and said that his client was supposedly committed to complete transparency, that they had withheld nothing, and that he provided explicit instructions to Vivian Lee Thoreen to produce everything without exception. Jamie's lawyers also claim that whatever documents exist regarding electronic surveillance, to the extent that any, this is confusing. Mr. Spears' counsel also, so Big Sloppy also claimed whatever documents exist regarding electronic surveillance, to the extent that any, would be part of the production. Oh, okay. So y'all probably know this because y'all are all, real smart and things. But whenever people put this, see this open parentheses and then sick in italics like that, that means that you're quoting somebody and you're recognizing that that somebody made like a grammar or a spelling error, but you're quoting them. So you have to quote exactly what someone said, but they're the one that made the spelling error, not you. So it's kind of like a sassy thing you can put in there whenever you're quoting someone and trying to hint to the fact that they don't know how to write. So this is what it's supposed to say. Mr. Spears' counsel, so Big Sloppy, claimed whatever documents exist regarding electronic surveillance, if any do exist, that would have been handed over by Vivian Lee Thoreen. And I told Vivian Lee Thoreen to hand over everything and not hold nothing back. So if she's holding stuff back, that's not my problem, is what Big Sloppy is saying in this November 5th email. Like other representations made in court on January 19th, these promises by Big Sloppy are tantamount to a big lie. You're right, Matt. I'm glad you're calling it a lie now. You're correct. By objecting to every single one of Britney's deposition notice requests, Jamie has done the exact opposite of what he repeatedly promised. Jamie's tactics were to create a false record and a narrative, and they should not be countenanced. Even putting aside his statutory duty and his fiduciary obligation, Jamie has waived any of these objections whenever he didn't do it before his first deposition. B, Jamie must be compelled to produce documents at his deposition. Jamie objects to the document request as unduly burdensome and unreasonable, duplicative, and cumulative because he claims that Britney requested similar information and requests for production propounded on him. But this objection is contrary to law. California's Code of Civil Procedure does not preclude a party from seeking similar documents through different methods of discovery. The inspection of documents procedure is quite different from a deposition at which a party is required to bring documents. Nothing in either Section 2025 or 2031 suggests that seeking documents under one statutory procedure bars a litigant from seeking the same documents under the other. So what's going on here is Jamie has objected on many grounds, and one of his grounds is that for him to produce documents would be unduly burdensome and unreasonable. And this specifically is for his deposition, right? You have to produce certain documents for your deposition specifically. So Jamie is saying, no, I shouldn't have to give you those documents because I already gave them when you requested them in the original discovery. But the objection is contrary to the law. The inspection of documents is different. So consistent with the court's ruling in Carter, Jamie still has to bring the requested documents to the deposition. The selection of the method of discovery is to be utilized and to be made by the party seeking discovery. So Jamie doesn't get to decide whether or not I ask for these, I get to decide, right? So this is what this is saying. The method of discovery utilized is to be made by the party who's seeking the answers, in this case, Britney. Jamie doesn't get to dictate the method that they turn over the documents. If it's a statutory method that works under the law, then they have to turn it over. Relatedly, Jamie claims the document requests are duplicative, unduly burdensome, oppressive, and harassing because Jamie already voluntarily produced some of the same documents. He is wrong on multiple levels. Initially, a party is permitted to use multiple methods of obtaining discovery, and the fact that information was disclosed under one method is not a proper basis to refuse to provide discovery during using the other method. Seems pretty obvious to me. A party may use multiple methods to obtain discovery, and the fact that information was disclosed under one method isn't basis to refuse to provide it under another method, which is what Jamie is doing. And Matt's saying, okay, it's already been decided. Jamie's objection that he has already produced some of the requested documents, even if it is true, is not a defense. To the extent he intended to actually rely on this objection, Jamie needed to demonstrate that a production would actually be unjust and inequitable, but he fails to do that. Instead, he relies on his made-up defense that he has cooperated and transferred all the documents. Mr. Spears also astonishingly objects on the basis that there are no further documents he could provide to respond to the deposition notice, because he supposedly has produced them all. If this were true, and it is not, then why does he not so state in a single response instead of making countless boilerplate objections? Why does he not appear at his objection and so state on the record under penalty of perjury? Why did he not identify the requested documents by bait numbers? Why does he not correlate them to the document requests at issue? And why does he not simply provide answers to the following questions and requests that have been posed to him repeatedly with Bates labels? So basically he's saying, Jamie, he has all these different objections, but one of his objections is, oh, I don't have anything else to give you. And Mathew Rosengart is just boldface calling them liars at this point. He says, well, then, okay, fine. If you don't have any other documents, then can you just answer these questions? What were the total fees taken or received by you or any entity that you had any interest in from Britney? What were the total fees taken by TriStar from Britney? Why don't you produce all documents showing any money received by you, which has been affiliate, or any entity which has been affiliated with you since 2008 as an officer, director, employee, or other? Why don't you produce the organized documents and corporate formation documents for all entities? Why don't you produce all the organizational and corporate formation documents for the conservatorship? So basically what Matt is saying is, Your Honor, he's going to come out here and tell you that he doesn't have these documents, but this is all stuff he definitely does have, so he's lying. Oh, shoot. As referenced above, despite our repeated and ongoing requests while relying on the facile and false claim that he has produced everything requested, Jamie also fails to produce all text or email communication between and amongst TriStar, Black Box, himself, and his counsel. Y'all, those are so deleted. I do not think that those are ever going to see the light of day. But who knows? I don't know anything. That's just my conspiracy theory. Indeed, he falsely claims it, quote, didn't happen, Your Honor. In short, as part of their efforts to stonewall and hide the truth, Mr. Spears has engaged in improper, disjointed, and incomplete document dumps rather than a professional, organized, and labeled production of documents. More pointedly, he has failed to produce any documents pursuant to and correlated to the deposition notices. Not one. And then he says sanctions are appropriate where a party refused to produce documents in an organized and labeled manner. C, the requested documents are at the heart of the discovery in this matter. Jamie also objects that the document requests attempt to relitigate the entire 13-year conservatorship and innumerable final court orders, and are not relevant and not reasonably calculated to lead to the discovery of admissible evidence. Matt says, nonsense. Discovery may relate to the claim or defense of the party seeking discovery or of any other party to the action. In this case, the document requests directly relate to Jamie's role and conduct as former conservator of the estate, which are also directly at issue under Shine, Casper, Bauer, and Hudson. These are the three of the cases that Matt always relies on. There's another one called Mueller. But what is going on in this one is, listen, even if Jamie was onto something about duplicative and all this other bull crap he's talking about, the documents we are asking for are literally like the most important documents in the case. So he's trying to poo-poo, but they are at the heart of the case and we need them. In this case, okay. The requested documents are not only reasonably calculated to lead to the discovery of admissible evidence, they actually go directly to the heart of numerous pending matters, including Jamie's fee petition and accountings. Under the circumstances, Jamie's objection that the requests are somehow not reasonably calculated are legally frivolous. So his objections are legally frivolous. D. Mr. Spears' boilerplate objections cannot block access to the critical documents and information at issue. Mr. Spears' remaining objections are also frivolous, as demonstrated below. The objections that the document requests are vague, ambiguous, overly broad, unduly burdensome, oppressive, and seek information that is not in Jamie's possession or control all fail. So this section we're going to talk about the objections that Jamie made. So what happened is Jamie made a bunch of different type of objections. And when he did that, he created like possible legal loopholes for himself. So each and every type of objection, Mathew Rosengart has to go in and actually say, and this is why this one won't work. And this is why this one won't work. And this is why, Jamie hasn't successfully created a legal loophole for himself, right? So on top of all these other objections Jamie has made, right? Like, let me see. He should be compelled to produce the documents. The required documents are at the heart. So on top of all these other objections, like they're unduly burdened, so blah, 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 they all just fail, right? The boilerplate, it fails. It all fails. And this is why. Jamie's objections on grounds of purportedly vague and ambiguous requests or the terms you or your are all baseless. Where the question is somewhat ambiguous, but the nature of the information is apparent, the proper solution is to provide an appropriate response. So Jamie's acting like some of the questions that Mathew Rosengart asked him are like they could be like answered in either way. Oh, sorry, I have something in my eye. Mr. Spears, Jamie, also fails to support his baseless, burdensome, and oppressive objections, right? So Jamie is saying that Matt's requests of him to produce these documents for his discovery are burdensome and oppressive to Jamie. And Mathew Rosengart saying that's bullshit. That's no, absolutely not. He asserts all of them without any factual support whatsoever. The objection based on burden must be sustained by evidence showing the quantum of work required. While to support an objection of oppression, there must be some showing either of an intent to create unreasonable burden or that the ultimate effect of the burden is okay. So this is the legal standard that Jamie would have to meet to prove that Mathew and Britney were being unreasonably burdensome. And Matt is saying, I'm not doing any of this stuff. I'm just asking for basic stuff that Jamie has and he's acting stupid. Like that's basically this whole filing. Jamie fails to make any showing as to burden or oppression. The objection of burden is valid only when that burden is demonstrated to result in injustice. So Jamie would have had to demonstrate the burden of this, and he just didn't even include one fact. He didn't even try to demonstrate it. For these reasons, Mr. Spears' objection that the documents may be obtained from other sources and other means of discovery and that the burden and expense is going to outweigh any benefit are completely meritless. Additionally, to the extent that Jamie objects that the document requests are, quote, oppressive because they do not have any time limitations, this argument is meritless. Again, no showing has been made of any intent to create an unreasonable burden, and any objection based on lack of temporal definition is hypocritical. We're only here today because Britney Spears was under her father's infantilizing control for more than a decade. Further, the evidence shows that the conservatorship was conflicted from the very outset. Do y'all hear that over there at Winston and Strawn? Do y'all hear that? Was the owner or is now the owner? was a director or is now a director. As it turns out, it doesn't actually matter when somebody had a conflict of interest if they're still acting in the capacity where the conflict exists. I tried to tell y'all that as a 3-month attorney, but all y'all on the executive board didn't know how to damn act. Okay. The conservatorship, the evidence shows the conservatorship was conflicted from the very outset when, among other things, Jamie violated the rules of court by obtaining a substantial loan from Lou Taylor's company, TriStar. Then hiring TriStar, at that point just a little baby company, as her business manager. Any claim that Jamie faces, quote, oppression, such that he cannot respond to discovery relating to his own oppression of Britney Spears, is, to say the least, rich. Mr. Spears put his conduct at issue, and he must face the consequences. Okay, little number 2. Jamie's objections that the document requests seeking privileged information fail for numerous reasons. Okay, so the next objections that he wants to make are that the document requests seek privileged information. So basically what Jamie and Big Sloppy did is they went down the list and used every single excuse that they could possibly use to not do these. Every single excuse that they could possibly use to not give over this information. And so poor Matt Rosengart is having to spend, who knows, this is probably a $10,000, $20,000 filing with how much time had to go into it. And that's not counting the $10,000, $20,000 filing we read yesterday. As far as, I mean, even the lowest level people on this document who wrote the first drafts and stuff would have been billing out at least $500 an hour to Britney's estate. Now, maybe they're giving her a discount or whatever, but it's very expensive to go through and nitpick apart all these bullshit objections. And that's what's having to happen here. Jamie's objections on these grounds are meritless. Which grounds? The ones that claim that all their information is privileged or protected. And even if they're not privileged or protected, they've been waived. First, to the extent any privilege was claimed, Jamie should have supported the claim with actual facts, right? Factual information for other parties to evaluate the merits of that claim, such as a privilege. Here is a precedent. If an objection to a document request is based on a claim of privilege or work product, then the response to the request shall provide sufficient factual information for the other parties in the case to evaluate the merits of that claim. The party claiming the privilege, that would be Jamie, has the burden of establishing the preliminary facts necessary to support its exercise, and Jamie has failed to do that. The second reason that it fails is now that Jamie has been suspended as conservator of the estate, he no longer holds any attorney-client privilege. The successor fiduciary became the holder of the privilege in all communications between the fiduciary and his lawyers regarding the estate, whenever they occurred. And that is the Mueller case. There's another one called Stein, and he always quotes them together. Because fiduciary is holder of the attorney-client privilege in his or her capacity as such. So the next fiduciary that comes along becomes the new holder as to the confidential communications between the previous conservator. Now, in Britney's case, we don't have a secondary conservatorship. It just ended. So because he was suspended, Jamie quite simply has no privilege to claim. Third, as noted above, Jamie also waived any privilege claims in addition to failing to object timely when his counsel promised unconditional cooperation, complete transparency without conditions, and that Britney Spears was welcome to everything. But even further than that, Jamie's counsel stated he had provided, that's Big Sloppy, explicit instructions to Vivian Lee Thoreen to produce everything without exception. So under Mueller and Stein, Jamie does not hold any privilege, so he can't plead any privilege. And in any event, even if the documents at issue were privileged, and they are not, Jamie waived any privilege because he didn't object on time. Jamie also objects that the requests somehow violate his right to privacy. This too is improper and makes no damn sense. I put the damn in for y'all. It is Jamie's burden to justify the objection, and he has failed to do so. Jamie's position also reeks of hypocrisy given his gross violation of his daughter's privacy. I love that sentence. One more time. Mr. Spears' position also reeks of hypocrisy given his gross violation of his daughter's privacy. So he's a hypocrite. because he violated Britney's privacy the whole damn time, and now he's worried about his privacy. That is ridiculous. Finally, any claimed right to privacy must be considered against the historically important state of interest of facilitating the truth and ascertaining the truth in connection with legal proceedings. Even as Mr. Spears hides it, the mission remains to ascertain the truth, which necessarily trumps Mr. Spears' evasive and fabricated privacy rights. All right, we're almost done. Mr. Spears' final hodgepodge objections also fail. Finally, Mr. Spears purports to assert hodgepodge objections that the document requests are, quote, speculative, lack foundation, improperly assume the existence of hypothetical facts that are innocent or unknown to Jamie, and they call for legal conclusions. In asserting these boilerplate objections, Jamie does nothing. We got a rogue comma here. Jamie does nothing more than cite boilerplate buzzwords into his general objections. He fails to incorporate them anywhere else. He fails to justify how the document requests are so formed. This is because he is once again wrong. And he is once again seeking to evade the truth and its consequences. As demonstrated above, and as the requests themselves demonstrate, the requests are narrowly tailored to essential pending issues, which were put front and center by Jamie himself. Okay, so then we have a footnote here. The use of these general objections, like Jamie uses here, is improper under the California Civil Discovery Act, and their bald assertion is in this context demonstrates Jamie's desperation and lack of any factual basis for them. For all the foregoing reasons, and for the extra reasons in the record, Jamie should be ordered to produce all documents contained in and accompanying the second amended notice of deposition of James P. Spears. In the meantime, we repeat our plea to Mr. Spears, which is a plea for decency, a plea that any father who truly loved his daughter would embrace. Please fulfill your legal and fiduciary obligations, and please stop harassing and bullying your daughter. Mr. Spears, and they put this in the footnote, should also withdraw his misplaced, inappropriate, and abusive deposition request and leave his daughter alone. Respectfully submitted, Greenberg Trarg, Matt Rosengart. So I want to show y'all where you can find these documents. Let's see. The Exhibit A is the document we read yesterday. I want to just show y'all where I keep these documents. So it's in my drive. It's in the court documents file, which is linked below. And I have all these documents. It's all here for public. And if you go to the 2022, this is where the documents from 2022 are. Again, this is incomplete. I will go and purchase the other 2 documents that were filed yesterday, and maybe I'll do a live later, or maybe I'll do a live tomorrow. Other things that are going to be upcoming that I'm going to be reading besides the other 2 documents that were filed, which is a declaration of Britney's lawyer, Lisa McCurdy, and a statement from Britney herself, which is like 250 pages long, but I'm sure most of it is exhibits. I'm going to be reading that. I'm going to be going soon through the Lou Taylor, Brian Kuchar lawsuit because it keeps coming up in this case. And I think it will be important for y'all to understand what happened in the case. I have read it, but it was like 2 years ago when I read it. So that is stuff that's going to be coming up very soon. As far as this filing, if you want the TLDR, it's basically what I said at the beginning of the video. It's Jamie and Big Sloppy are objecting to giving over any and all types of information. And now poor Matt Rosengart and his team over there at Greenberg have had to come out and basically, pretend like any of this stuff right here makes any sense. Like Jamie's objections really don't make sense for all these reasons. But unfortunately, whenever you're in court, a lot of times people can just throw stuff at the wall and it'll stick. So basically they need Jamie to answer questions. He's not answering questions. He's not giving them documents, and he's using all these fake excuses. Okay. Britney apologized to her earlier this year. Yeah. Okay. Anyway. Okay. So this live is already, longer than y'all know. I don't like to really have these long lives, and people seem to be dropping off now. So, yeah, I'll be reading that other stuff soon. Keep a lookout. I am still on the BAM case. I am still very concerned about his safety. There were pictures of him and Lima Yevremovich circulating on the internet. And that concerns me because Bam Margera called Lima Yevremovich the worst guardian ever. I also understand that some of y'all have sent me a video. I understand somebody has contacted Lori Schiller, which is the person who seems to have initiated the conservatorship of Wendy Williams. So I do plan on catching up with all that. As y'all know, I have been planning my engagement. And then the week before that, I had graduation 2 years late. So I am getting back into it. I do plan on, ramping up the content very soon. And make sure you are subscribed to BJ Investigates. We finally hit our 10,000 subscribers. So we will be doing a iPad Air giveaway. If you have not entered yet, we will be doing the drawing later tonight and letting y'all know who wins. So go over to BJ Investigates and do subscribe and all that. Just because we hit 10,000, we still haven't chosen the winner yet. So there's still time. We will choose that winner tonight. And yeah, just be on the lookout. Like I don't really have any specific times that I do stuff. Like I usually do stuff in the morning. So just make sure your notifications are on and you're able to catch the lives and the videos when we put them up. That's all I have for right now. Facts ain't defamation. Love you.